Hello there, a very good evening and welcome to our brand new show, The Role of Law. Of course, our first episode was aired last week regarding the 19th Amendment to the Constitution. And well, of course, when we were recording that show and when it was being aired, the 20th Amendment to the Constitution had not yet been gazetted. But there were massive talks about the 20th Amendment to the Constitution. But now, times have changed. We all have seen the 20th Amendment to the Constitution. There have been many reports regarding the content of the 20th Amendment. There have been many views that have been expressed by political parties as well as experts in the fields of law and other important fields. Of course, today we are here on Role of Law to discuss the content of the 20th Amendment and how it will affect Sri Lanka in the future if it is passed in Parliament. And to do that, of course, we've got with us an expert in the field of law, none other than President's Counsel Zaruk. A very good evening, sir, and welcome to the show.
Good evening to you, Shalal. Thank you very much for inviting me.
Sir, we've had the 20th Amendment. We've had a little bit of time to analyze it, of course, enough for an in-depth analysis. However, let's first take a look at a few of the provisions of the 20th Amendment, or some provisions in the Constitution that the 20th Amendment has not repealed, and one change that has been brought about through the 20th Amendment to the Constitution. Let's have a look.
The provisions in the 19th Amendment limiting the President's term to 5 years and the two-term limit on the President has not been repealed. Under the 20th Amendment, the President's immunity from suit has been completely restored under the 20th Amendment. The 19th Amendment allowed for any citizen to bring an application under Article 126 against the Attorney General in respect of anything done or omitted by the President.
So those are some of the provisions, two of the provisions in the 19th Amendment to the Constitution that have been preserved, and also one amendment that has been changed, which is the immunity of the President. Let's start off with the first two that has been preserved. Do you believe that that's the best choice, or could we have just done away with the term limit and increased the President's term to 6 years again?
No, Shalal, I don't think that's correct. I mean, that very clearly it was the policy of this government that the term shall remain 5 years. And I believe the President also insisted on that, that the term shall remain for 5 years and only two terms thereafter. And as regards the immunity, you know, that is something which has to be looked into, because what they have attempted to do is to go back to the earlier Constitution of 1978, the provisions of 1978. You know,
right.
The whole issue is the 19th Amendment brought in provisions which has completely distorted the 1978 amendment, the Constitution,
right,
which was a presidential constitution.
Okay.
A presidential government constitution.
Right.
So in such instances, that immunity is a necessity. Otherwise, the president will, everybody, Tom, Dick and Harry, will be going to courts, taking the president for various decisions. There is no other time for the president to think of the country and rule the country. It will be a question of devoting time for the cases in court.
But according to the 19th Amendment, that specific provision is that people can invoke their fundamental rights jurisdiction under Article 126 against the Attorney General and not per se the President.
Yeah. So
and of course, the courts have always exercised caution in intervening in the matters of the executive. And has there been a problem where, as you said, every Dick, Tom and Harry goes to court and files action against the President since the 19th Amendment was introduced?
It did happen too. But anyway, let me go back. It has practically brought back the earlier provision. It said, I'm talking about the 78 Constitution, it said, provided that any such proceedings in relation to the exercise of any power pertaining to any such subject or function shall be instituted against the Attorney General. So we are going back. What is so sacred about this 19th Amendment? Everybody is worried about the 19th Amendment. Don't attach any sanctity to the 19th Amendment. This is an amendment of, not a constitutional amendment, it is a confusional amendment. This confused the whole issue. This has distorted the completely a presidential system of government. this one. You know, so as a result, don't bring in portions of the 19th Amendment which has been brought in and then say, so therefore what do you think of this immunity clause and all? Go back to the 78. Go back to the 78, where people like H.W. Jayawardena and all of them got together and drafted this constitution.
Right.
You know, and then and then they looked into all this. So and J.R. was very firm that a president should be able to act without going to courts for every decision he takes.
But we need to understand the context in which the 19th Amendment really was passed in Parliament. That was what the people at the time were asking, because we saw the 18th Amendment to the Constitution even removing the term limit of the President, amassing an extraordinary power in the hands of the President. And there was, at the time at least, a consensus among the general public that we need to move towards a more parliamentary system, a Westminster democracy system, if you will. And that is the context in which the 19th Amendment was brought into the Constitution.
Sharan, we had this from 1948 till up to 1972 and thereafter till 1972. But 1972 too was not a presidential system.
Right.
Which Mr. J.R. Jayawardena brought in a new constitution based on a presidential system of government.
Okay.
Now, if you look at the 1978 constitution, the design, the form, and the context of it, and the contents of it, the whole thing is designed for a presidential system of government. You cannot hybridize it. You cannot bring in, dilute it.
Okay.
If you want to do away with the presidential, go back to the Westminster system, where the Prime Minister and the government, where you have a figurehead like the Queen, the Governor General.
Okay.
Then, of course, he said, you have to have a different constitution. You can't bring in something like the 19th Constitution and distort the whole thing. Then the thing should be, scrap the thing. Why didn't they scrap the whole thing and bring in the Westminster Constitution?
I believe that was
without scrapping the Westminster Constitution,
right.
What did this do? They said, oh, the presidency is wielding too much power. Yes, of course. That constitution was designed for president to wield powers. So you want to cut it out, and then what happened? You know, there's a principle of, you're a lawyer yourself, you should understand. There is a principle of sovereignty.
Okay.
It is indivisible. So similarly, when power is vested on the president, you can't divide power between the president and the prime minister.
Right.
Unless the power is devolved.
Right.
Devolving is different. The president devolves certain powers to the prime minister, is a devolutive thing. But you cannot divide the power between two. You shall rule this, you shall rule that. No way. And that is what happened. And that is why the 19th Amendment is a disastrous amendment. This should have been thrown overboard completely. You cannot bring in an amendment like the 19th Amendment to a presidential system of constitution, which are designed to do so. That is the reason why there was chaos. The best example of the chaos was the April Easter bomb attack, when the Security Council had all the information. Every information was fed to the president. And the Prime Minister was also told, I don't know whether he got it or not. None of them met. Why? It is like, no, everybody's cake is nobody's cake. So that is what happened. So this 19th Amendment is one example of the disastrous consequence of the 19th Amendment. This should be thrown overboard. If you want to have a Westminster government, as you say, with the Prime Minister headed on, then knock this constitution off completely and bring in a constitution. That's exactly why a new constitutional committee commission has been appointed, rather.
A committee has been appointed to
draft a new constitution. To go into it, and 2 years' time. And within that 2 years, the president can't be pressurized by working in this, what shall I say, disastrous 19th Amendment.
But at the time, the 19th Amendment...
The president should have the freedom to act within these 2 years, because we are under a presidential government.
But at the time the 19th Amendment was really promulgated in Parliament, it was hailed as the swan song of democracy, finally a turn towards a more democratic governance system here in Sri Lanka.
How could it be? Was it so? Was it so by experience? It was not so. It never happened. You could have great visions, but when you put that into action, what happened?
But what if I tell you that we had two of the most peaceful elections here in Sri Lanka after the 19th Amendment was brought?
That had nothing to do with the 19th Amendment. The peaceful elections were because that had nothing to do with the peaceful because the elections were always peaceful. Even before the 19th Amendment. Also
Before the 19th Amendment?
Also, we had a peaceful election,
I think
comparatively.
we
But what you say is, over a period of time, you say that there had been no. That is not the reason why we had peaceful elections. Don't attribute it to the 19th Amendment.
Well, I'm actually attributing it.
No,
let's take a look at
we also had a very strong elections commission. Not a commission, chairman of the elections commission.
Yes.
A very strong personality. A very strong.
We had election secretariat before that.
Before that.
Yes.
So he was very, very firm, and he said nothing doing.
President's Counsel Zarruq, before we get into the topic of elections commission, let's take a...
Perhaps that may even be one of the good features. I won't say that you are just highlighting one good feature.
Okay.
Maybe, I accept that there should be an independent commission, elections commission. And the elections were conducted very peacefully, I admit that. But that doesn't mean that it should have come from maybe that it came from the 19th Amendment, but then wasn't it there earlier?
It wasn't.
It wasn't. So then, I don't say therefore the 19th Amendment is all, therefore we should retain the 19th Amendment. No way. Let's retain the Elections Commission as they have done.
Okay.
But we'll knock off the 19th Amendment.
Right. Let's take a look at a few more provisions of the 20th Amendment to the Constitution and then continue our discussion on that.
The Constitutional Council has been completely repealed. It has been replaced by the Parliamentary Council. The President's representative and 3 representatives of civil society who were included in the Constitutional Council are no longer included in the Parliamentary Council. The Parliamentary Council only exercises observational powers. Under the 19th Amendment, the Constitutional Council was tasked with approving recommendations sent by the President for appointments to high posts and independent commissions. Under the 20th Amendment, it is only an observation that is given by the Parliamentary Council. The National Procurement Commission and the National Audit Commission have also been abolished under the 20th Amendment. The transitional provisions of the draft allows for the members of the Elections Commission, the Public Services Commission, the National Police Commission, the Human Rights Commission, the Commission to investigate allegations of bribery or corruption, the Finance Commission and the Delimitation Commission to continue to hold office. Under the 20th Amendment, the appointment of the Chief Justice, Justices of the Supreme Court, Chairman and Justices of the Court of Appeal, and members of the Judicial Services Commission are made by the President. The President will entertain observations from the Parliamentary Council regarding these appointments. The President is also vested with the power to appoint the Attorney General, the Parliamentary Commissioner for Administration or Ombudsman, as well as the Secretary General of Parliament under the 20th Amendment to the Constitution. The President also has the power to make appointments to all commissions, and the requirement for approval from the Constitutional Council has been done away with under the 20th Amendment.
So the Constitutional Council, it was a topic of much debate in the past through the 19th Amendment. Some said that the Constitutional Council exercised better checks and balances, especially when it comes to high appointments. But now the Constitutional Council has been removed, of course, as was promised by the Sri Lanka Podujana Peramuna government. But is this the best course of action?
Yes, indeed.
The Constitutional Council?
Indeed, because it was creating a lot of issues. Now remember, it came up earlier too on the 17th Amendment, I believe. And what happened?
Yes.
And they failed to nominate, the whole thing became functus at the time because the parliamentary nominations didn't, the appointments didn't come through, and I think the President at that time had to resort to the doctrine of necessity to make certain appointments.
Okay.
So I think that needed very much indeed, and this, whatever it is, even the last, what do you call it, the Constitutional Council consisted of the majority of them were all parliamentarians.
Yes.
Only 3 nominees from outsiders.
Yes.
And what were they doing? They were not functioning at all. They were just saying yes, but I don't think they have ever dissented or said made their point of view right. And what was their function? What was the function of the commission? When the majority 5 plus 3, okay, fine. What was the function of that commission?
Constitutional Council.
The Constitutional Council?
To vet the appointments of the President,
not to vet,
especially.
No, use the exact words, what is in the Constitutional Council, the functions. They recommend.
They approve the recommendation sent by the President.
They approve.
Yes.
Now, here what do they do? Here, No, they approve, but the appointment is made by the president.
Yes, the appointment is
Yeah.
made by the president.
But here the president shall seek the observation of the parliamentary committee. And then he will take that into consideration and make his appointment.
But at the end of the day, in all practicality,
Yeah.
it is the discretion is completely vested in the president.
So
There
was
is
it earlier?
no check and balance.
So was it earlier. So was it earlier. So was it earlier. And whether these three people were there or not, ultimately it was the president who appoints. So here there is a parliamentary committee which consists of the speaker who is to stand independent.
Right.
Then you have the prime minister and his nominee, the leader of the opposition and his nominee. And among the nominees, they should also ensure minority representation.
Right.
They do that.
Yes.
So as a result, there is, I believe, a wide, diverse
Group.
expression of opinions that will come through. So the other three need not be there. And they were, and there was the danger, in as much as itself, that some of them were representing NGO interests
Right.
in those nominations.
Okay.
And there were motives being attributed to it. And some of them were just doing nothing, they were just keeping quiet. So anyway, as far as it is, ultimate, the observations are made, the recommendations are made, but the ultimate appointing authority is the president. So I don't think there's anything bad about it.
But now you
Well,
question
actually, the parliamentary commission will be, rather, council will be more effective.
will be more effective in
Will be
just
more effective.
providing observations instead of directly getting
Of
involved in the
course,
appointment.
it will be a providing that will be taken into consideration by the president.
But what's the guarantee that it will be taken into
Of
consideration
course,
by
it
the
will be taken into
president?
consideration, even as much as it was taken into consideration earlier, the recommendations that were made.
It was not a consideration of recommendations earlier. It was the president nominates certain individuals to be appointed to commissions or other high posts, and the Constitutional Council has the full right to either say yes, he can be appointed, or no, he cannot be appointed, bringing about checks and balances. My question to you is that checks and balances element, you spoke about the concept of sovereignty, but there's also checks and balances that are required in a system of governments. There are three arms of the state, and they need to be kept in check and balance. What happens to that aspect of it when you do away with these?
It is there because there is a separation of the legislature is there. There is the judiciary is there.
Okay.
And there are you have checks and balances on that basis. After all, if there's anything wrong done, if the judiciary cannot intervene for certain reasons, certainly the legislature will make a big noise about it.
Well, you said that now there's a committee that has been appointed to draft an entirely new constitution, and this constitution, at least, or this amendment to the constitution was introduced as a transition from the 78 constitution to whatever new constitution that is drawn up by the committee that has been appointed. But now my question to you is, there are transitional provisions in the 20th Amendment to the Constitution that allows the Elections Commission, the National Police Commission, and various other commissions to continue to operate. So within a 2-year period, what really is the motive behind the president amassing the powers to appoint members to these commissions, the chairmen to these commissions, all to him if he really is planning on drafting a new, or he or the government is really planning on drafting a new constitution within a 2-year time period, if there can be no appointments made during that period?
As I said earlier,
Okay.
we have gone back to the 1978 constitution.
Okay.
You understand?
Yes.
And the earlier 78 constitution, before the amendments came in, did not envisage any of those things.
Right.
That's what you are thinking of now.
The independent commissions.
They also.
Right.
You understand?
Okay.
So did the 1948 constitution, the Solberry constitution, nor did the 72 constitution.
Okay.
These are new concepts that were brought in, and there were pros and cons have been looked into it. You know, there are commissions sitting here, but it's a question of appointing. Those schedules are left out,
Yes.
set out.
Yes.
In those schedules, they say who has to be appointed and what has to be,
Right.
what they have to do. You know, as I said earlier, this you cannot divest a presidential system of government cannot be diluted, I said, by the 19th Amendment, or cannot be distorted.
Okay.
It is whatever the president has done is to do away with those distortions.
Right.
And if a country has to exercise executive power, he has to have the right to have executive power. You know, his power cannot be taken over by various commissions and committees. If a president can't appoint his IGP, if he can't appoint or remove the IGP as it happened, what's the point? What's the point? Now look at what happened to the IGP. We had a situation where we had an IGP could not be removed.
Right. But that was because mainly the Constitutional Council did not agree.
That's right. So in such a situation, so I believe these are matters that will be gone into in depth as to what the checks and balances should be. But within the next 2 years, you know, he must, as a president, should be able to exercise his presidential executive authority. You know,
right.
if that is so. So that is the reason why these powers have been rather taken away or rather modified, you know, to some extent.
Right. You spoke about the appointment of the Inspector General of Police, and also, according to the 20th Amendment to the Constitution, the Attorney General and many high positions as such, even the Chief Justice, is the sole discretion. We'll get to the point where we discuss about the judiciary separately, but the Attorney General and especially the Inspector General of Police is the sole discretion of the President. Do you believe that these individuals that are appointed to these positions can exercise certain level of independence, if not any level of independence?
Why not? Have we not had judges exercising independence? It depends on the individual. Look at, for example, Justice Neville Samarkand, Chief Justice. He was not appointed through constitutional councils. He was appointed by the President Jayawardene himself, but he stood firm. There are a number of judges who have been appointed, who were given in the past, and they said, oh, we had a lovely independent judiciary those days. It was the glorious days. The glorious days when you had independent judges, they were not appointed through commissions. To a great extent, the independence of judges do not depend on commissions. It depends on the individual, his character. His independence is determined by his character. Not by the appointment he made. So he doesn't, oh, you think that simply because the president appoints a judge, oh, I should be beholden to the president. No way. No way. I mean, look at our system of appointing judges is far better than even the United States. In the United States, judges are identified by their parties. He's a Republican judge, he's a Democratic judge. Oh my God, he's opposed to those things. I'm sure the Supreme Court is now weighed heavily in favor of the Republicans. So that is the type of talk. We don't have that. We don't say the Supreme Court is weighed heavily for the SLPP and not heavily for the UNP. We don't have that here. We don't have. So please, the independence of a judge does not depend on the commission or the person who appoints him. Depends solely on his character and his individualism.
So you were speaking about character and individualism, and that is really the essence of the independence of judiciary. But the Constitution can't really guarantee the independence and character of a judge. The Constitution can only set the procedure to appoint a more independent judge.
Whatever may be the appointment, you are talking only of appointment, but the delivery of a judgment, coming to conclusions. Right. Is he not motivated? Is he not motivated? Look at the past in 1978. Okay, when the Constitution, or the 13th Amendment for that matter, where 4 judges were against and 5 were for. Look at the other earlier judgments, how judges were removed, all that. You understand?
Yes.
The independence of the judges do not depend on constitutional appointments and on all that. It depends purely on their own, as I said, once again, I'm sorry to reiterate it over and over again, it depends on the individual.
President's Counsel Zarruq, also 2 of the independent commissions have been abolished, the National Procurement Commission and the National Audit Commission. Now, we know that Sri Lanka is famous for massive corruption scandals, especially when it comes to procurement matters, and it is the Audit Commission, or recently the Auditor General, who was mainly involved in revealing these acts of corruption and how state funds have been mismanaged. But now, in the absence of these 2 commissions, again, it falls on the President. The power really falls on the President to appoint an Auditor General. Again, my question to you is, can the Auditor General, who is directly appointed by the President, really exercise independence?
Why not? Why not? He could. He should. I think the sheer fact that there was a commission earlier doesn't mean that they were not acting independently. But most probably there must have been some reason why they should do, because there would have been bottlenecks and delays. That would also certain is a constraint. But let's see, wait and see what, because these were yet a bill. We do not know what proposals will come.
Of course, at the committee stage, there will be amendments being brought into this.
While at the stage of debating, there will be suggestions made. And at the committee stage, this is only a bill. We are not discussing a law.
Exactly.
So we do not know. So the pros and cons will be debated as much as you are raising these issues. I'm sure these issues will also be raised in Parliament.
Right.
And there will be pros and cons discussed, and they might make certain adjustments. You know.
Let's take now we are currently grappling with the question as to if the President can really hold the Ministry of Defence under the current constitution. Yeah. Like we spoke at the earlier show as well with the Attorney at Law Suren Fernando, we quoted the Minister of Justice himself, President's Counsel Ali Sabri, saying that the provision in the 19th Amendment contradicts with a pre-existing provision in the Constitution, and that is the reason why the President can still hold a ministerial portfolio. But the 20th Amendment really does away with this problem. Let's take a look at the provisions that fixes this at least.
Under the 20th Amendment, the President is a member of the Cabinet and the head of the Cabinet. The President is also vested with the power and discretion to remove the Prime Minister. The President also has the discretion to appoint ministers and assign to them any subject. The limit on the number of ministers that can be appointed that was imposed under the 19th Amendment to the Constitution has been removed. The President is now vested with the discretion and power to appoint any number of cabinet ministers, non-cabinet ministers, deputy ministers and state ministers.
So the 20th Amendment really turns the tables around as far as the provisions in the 19th Amendment goes. And allows the President once again to hold a ministerial portfolio. It just goes a little bit beyond that as well, saying that the President can appoint anyone he wants into the Cabinet of Ministers. And also, more importantly, the really controversial provision here, for me at least, is the fact that the cap on the number of ministers has been removed. There was 30 cabinet ministers and a cap on the number of cabinet ministers and 40 for non-cabinet ministers. Now this has been completely removed. Sri Lanka has a history with jumbo cabinets, and the wealth that we really spent on maintaining these cabinets have really not paid off. The return on investment is nowhere to be found. So are we headed to a situation like that again with these amendments?
That again, you are coming back again. We are talking on the 19th Amendment. And they are saying, well, the 19th Amendment is sacred, sacrosanct. They have restricted it. Therefore, why has it been removed?
Okay.
Now, look, we are going back again, as I said, to a presidential system of government which has been enacted in the 1978 Constitution. In the 1978 Constitution, these issues didn't come up at all about jumbo cabinets and all that, though we had the jumbo cabinets and all these things came in subsequently. The reason is, I'll tell you the reason. Reason is, earlier there was a cut-off point of 10.5%.
Right.
You know, and in 1989, during the time of Prime Minister Premadasa, who was about to come into the presidency, the last act that was passed in the 1989 Parliament was bringing down the cut-off point of 12.5 to 5%.
Yeah.
To accommodate minority governments.
Minority parties.
Minority parties. As a result, you had to accommodate all of them to have form of government. We have never had after 1989 up to 2010 when President Mahinda Rajapaksa got a substantial majority in Parliament.
That was also through crossovers.
We never had, no party had absolute majorities. No, I'm not talking about crossover. He won in 2010.
Yes, sorry.
After the war.
The 2/3.
He won not 2/3. He never got a 2/3, but he's almost 2/3. You know? But, so as a result, no government was being able to be formed without the help of these minority parties. And these parties who had 5-10 seats became kingmakers. And that's what happened to this country. And as a result, that is the one that even has created all these ethnic animosities. You know, because they were kingmakers, corrupt kingmakers. So, as a result, the whole system collapsed. So, this particular constitution of 1978, which J.R. was designed with a cutoff point of 10.5%, was outraged. You know, I would say it was outraged. It was, if I would put it, the modesty of it was outraged, and the 19th Amendment actually raped it completely, raped it. So you are trying to hybridize it. You are trying to fix it together and say, you know, you can never do that. So if you want to go back to the Westminster system and all that, as I said earlier, scrap the whole thing and have what is the status of a Prime Minister? In the words of Mr. Premadasa himself, the late Mr. R. Premadasa, I am a glorified peon. That is exactly what the presidential constitution of 1978 made the Prime Minister. He was just given a name, not even primus inter pares. He was not even first among the equals, because the president was the first among all equals. Because he presided at the cabinet.
Exactly.
So, as a result, I'm telling you, as a result, now when the 12.5% was brought down to 5, then all these confusion came in, and then the cabinet started to bloat. Each one of those guys have to be given ministerial positions, and each of those guys who crossed over has to be made ministers. And all those guys who are in the opposition who are trying to cross over and give them the majority had to be given ministers. So this bloated.
So what if I pose a question to you like this? Now, you pointed out that initially it was the electoral system that really led to governments having to accommodate many members as they have to accommodate minority parties and so on and so forth to form a government. But let's see how we fix that really. The electoral system is still the same, but we've removed the cap on the number of ministers. Don't we really go back to the problem that we were trying to initially avoid?
No, you can't know the cap. You can't, once again, if you have a two-third majority and all that, why do you want to have a cap? Why do you want to have a cap at all? I mean, what cap at all? Why should you have a cap on these ministerial things? I mean, why should it be even 25? It can be 10, 15, 25, 30 or 35 or whatever.
Well the cap really doesn't speak about a minimum limit.
No.
It just says the maximum amount has to
why
be 30.
Why should it be? Why should there be a maximum?
So you're of the opinion that Sri Lanka should have more than 30 ministers?
No, I'm of the opinion that the Sri Lanka should be able to have number of ministers as it needs.
As it needs?
As it needs. So if we are a developing country and if there are so many sectors of development, and if you need ministers to handle that, we should need more ministers. You know, I think J.R. also presided over a large cabinet.
Right.
You know, so did Premadasa, so did everybody else. You know, what is this? Suddenly you are trying to constrict these things.
Well, it was the subsequent issue that you spoke about.
That's right. But
it was the subsequent...
You know, I don't know, but the point is that I am against, either way, I am against fixing a minimum as well as fixing a maximum. You follow? You should leave it to the president of a country.
But this was really brought in.
Why should you restrict the presidential powers? He is the one, if we have elected the president, this last time we have elected this president with 6.9 million, the majority of the people of this country vote for a presidential system and we vote for a president. It should be left to the president to determine what he said think fit.
So no to any checks and balances.
Why should we?
We shouldn't have checks and balances on the president?
Don't bring it as checks and balances. Don't elevate that to checks and balances. You can say needs and appointments.
Okay.
If the president feels that I need a bigger cabinet, he should be left with it. You know, it should be the.
So could I bluntly say that you are for president having unlimited powers?
No, Now again, you are confusing the appointment of number of ministers with unlimited powers.
Okay.
Now don't confuse powers and the number of ministers. No, I think without a cap, I must say, a president would act prudently. He is not going to give cabinet ministries to everybody.
Maybe it's a lack of prudent presidents that has led us to this point.
Of course. If we have, now one of the very first things the president did as he came in, the current president did was, he had a very small limited cabinet of 15 ministers or something, is it?
It was sort of a caretaker government.
Caretaker government of 15 ministers, is it?
Yes.
Yes. So now that had to go through because of the COVID-19.
Okay.
Had to go for a longer time. Now we are coming, and now we have fairly about 26 or 20, no, we don't have 30. No?
30 cabinet ministers.
Yeah,
29
we have about
cabinet
28
ministers.
or 29 cabinet
29
ministers at the
cabinet
moment.
ministers, and yes.
Yeah. So
the full limit of the non-cabinet ministers.
So that's right, that's fine. So you can turn around and say, I mean, oh, the United States, being controlled by so many cabinet ministers in certain dictatorial countries, it might be even far less. I mean, the system of governance is different. I think, I'm not saying that therefore we should have a bloated cabinet. But I think there should not be a cap on the cabinet of ministers. That should be left to the president, and we, the people of this country, having elected the president, we expect him to act prudentially. And that he should use his discretion, and he should determine what it is. If he is going to have a cabinet of 50, 60 MP, well, that is ridiculous. So we will know, what is this? The president is not acting prudently. He is acting emotionally, or he is acting, give santosans to every minister who is supporting him. I leave it to the president. So it is the people who will judge the president when he appoints. So I don't think there should be a cap at all. And the people are the ultimate people. The checks and balances will come from the people.
Let's take a look at the final segment of the provisions that we've lined up for our discussion here on the role of law. And yes, we will analyze those as well.
The period in which the President can dissolve Parliament after the appointment of Parliament that was set at 4.5 years under the 19th Amendment to the Constitution has been reduced to 1 year under the 20th Amendment. The age limit for a candidate contesting for the seat of President has been reduced from 35 years to 30 years. Under the 19th Amendment to the Constitution, any person who is a dual citizen was disqualified from contesting or holding office as a Member of Parliament. The 20th Amendment has removed this disqualification.
So the reduction of the time period where the President cannot dissolve Parliament since the first sitting of the Parliament, this is a good provision?
Very good provision.
And what are the reasons?
Because reasons is that there can come to a crisis. Look at what happened last time. Minority government, you can't dissolve it. President and the Prime Minister are clashing and going on. The President had no way of dissolving Parliament. So the last regime was the best example.
But
why? I mean, I think when Mr. Dudley Senanayake couldn't go through with his throne speech.
Okay.
He dissolved Parliament. The governor, he advised the governor to dissolve Parliament in 33 days.
Right.
You understand that?
Yes.
When he lost the throne speech in 1960. Okay. I don't know whether you have read that history. In March.
Yes.
You understand? So, and also in so many instances, there have been where governments have advised, the Prime Ministers have advised the then Governor General to dissolve Parliament prior to the completion of the 5-year term. So I think that discretion should lie. You can't put a precedent, if it's bad government, if it's the government that has got into confusion, should not the President have the power to dissolve and go before the people? But why do you want to restrict the franchise of the people to elect a government? Should be only after 4.5 years. If a government is doing wrong, the people should have the right to throw them out.
What if the President is doing wrong?
The President will give that right to the people. When you dissolve it, what happens? The President is not appointing the government. It is the people who will elect their representatives. So you are going to deprive the people of electing the representatives for 4.5 years. So here at least I'm even against the 1-year rule. I don't say that you should even have 1 year. The people should be, if there is any time a crisis in Parliament, a crisis and conflicts,
right,
and governance cannot go like what happened in the last government.
Right.
For 4.5 years we had to put up with it because there couldn't be a resolution. The doctrine of necessities, all that was being discussed. Nothing happened. Even the Supreme Court held, no, you can't dissolve Parliament, or you can't even appoint a Prime Minister, or you can't even change the Prime Minister.
Yes.
So in such instances, should not the President have the right to go before the people? What is supreme? Is he going to appoint people on his own? No. The supremacy here is the right of the people, the franchise of the people. So you are going to give that right to the people.
Like what you said, dissolving the Parliament within 33 days.
Yeah.
isn't that
Sir,
a
during the-
usurpation of the people's sovereign rights?
No,
Their
no.
representatives who they've sent
No,
to Parliament
crisis.
are being thrown out.
There was a crisis at that time, not thrown out. He was not thrown out.
They were
You
dissolved.
didn't know. What happened was, at the throne speech, he lost.
Okay.
That is because at that time the Federal Party didn't support him. So as a result, the government was only there for 33 days. Then he went, the opposition then wanted the SLFP to be appointed, to alternate the government to be given. Saying that we have a majority in Parliament, we should elect the Prime Minister.
Right.
But once the throne speech was defeated at that time, under the Constitution, then Constitution,
Yes.
Parliament had to be dissolved.
Had to be dissolved. Right. No,
So
I'm just
then-
drawing an
no, I'm telling
analogy
you-
and I'm
no,
saying,
I'll tell you.
what
So
if
if that is so, but now, here you have another second chance given under the current Constitution.
there is 1 year?
1 year.
Okay.
And then, after 1 year, no Parliament shall be dissolved.
Right.
You know, I'm saying do away with that too. You know, because I think you are depriving the people the right to exercise their franchise for 1 year. You know, you will never ever restrict that. You follow? Elections could be held every 5 years or 4 years, that's a different matter. But never restrict the franchise. But anyway, that's a fair compromise, at least. That you are giving them a
President's
tolerance
Counsel
of 1 year.
Zarruq, we're in the final few minutes of our show and we save the best for last. One of the most controversial changes that has been proposed through the 20th Amendment to the Constitution is the removal of the disqualification of dual citizens from holding a seat in Parliament. Now, this is, to me, the most controversial provision that has been proposed in the 20th Amendment.
Most controversial, you say, is it?
Can you justify this?
Shalan, thank you very much for raising that issue. Thank you very much for raising that issue. Because these are much misunderstood concept.
Okay.
You know, if you, either you should have a citizenship of the country, or you should not be a citizen of the country.
Okay.
You understand?
Okay.
But if you are giving a citizenship of the country, you cannot be a second-class citizen. You cannot be half a citizen. You understand? So you are made, certain countries like Singapore doesn't believe in dual citizenship.
Right.
You don't give the right to dual citizenship.
Okay.
But if you have accepted, and Sri Lanka is giving dual citizenships to their citizens who are originally born here or who have something here, then you can't make them half citizens, 3/4 citizens, or 90% citizens. A citizen is a citizen. He is entitled to all the rights of a citizen, including the right of franchise,
Okay.
including the right to vote.
Right.
Otherwise, don't give him the citizenship. Tell him, sorry, you can come permanently reside there. We are very happy with you. But no, you can't be a citizen.
So, but even in the United States, there is a
Forget the United
bar.
States. Don't worry about the United States at all. I'll talk about Sri Lanka itself. You know, whatever it is, don't bring in, I think as far as we are concerned, if you are a citizen of a country, you should have the rights of all citizens. Otherwise, don't call yourself.
How can a person exercise the sovereignty given to him by the people if he has sworn an allegiance to another country?
But he has sworn allegiance here too. No? He's a
So,
dual
but
citizen.
then where does his
Then
loyalty lie?
If you see so, then if you say so, then deprive him of the citizenship. You are welcome to be here.
I saw a post on social media.
Then, if you don't give them citizenships, you give them PRs. Come
Okay.
and reside permanently here.
Right.
You know, but if you call him a citizen, then give him the right of every other citizen. You can't give a 90% citizenship, 99.9% citizenship, or a 50% citizenship. Oh, you are entitled to these rights, you are entitled to these rights, but not this. Then you are not a citizen. You are a semi-citizen, demi-citizen,
Right.
or a 3/4 of a citizen. I don't know. You know? So otherwise you give them PR. You say, no, we are not giving citizenships in this country. We will give you, we are most welcome to come as reside as a permanent resident here. Well, very most welcome. But since you are having a citizenship elsewhere, we are not going to give you a citizenship. But if you are giving a dual citizenship, that citizenship should have every right of every other citizen.
Let's talk about an issue. You were speaking about issues that happened in the past, and one real issue with a person who has dual allegiances or a citizenship in another country was the appointment of Arjuna Mahendran as the governor of the central bank. We are now grappling with issues of getting him extradited from Singapore to face charges here in Sri Lanka for robbing the people of their money. And we really can't do that.
You are getting back always. It's always when you come on MTV, you have to go back to the governor of the central bank and the bond issue.
But it's a pertinent analogy.
I'm telling you, it's very good. And thank you that you raised this issue. The reason here is that appointment of Mr. Arjuna Mahendran should never have been made. He can come in on a contract basis, but not on the basis of being appointed as the governor, because he cannot take the oath of allegiance to the country. Because why? The reason is he is a citizen of Singapore. And Singapore doesn't accept any other citizenship of any other country. So you can't sign an oath here. If you are a citizen of Sri Lanka, you can say I'm divided. I love Sri Lanka. I love the United States of America. But a Singapore citizen can't do that. So in the sense that appointment is all wrong and illegal.
So if
that appointment itself is illegal.
My final question to you, sir.
Anyway, that is the one that broke the government into two too.
Yes, exactly. My final question to you, sir, is quite simple. If a person has sworn allegiance to, say, for example, random example, the United States and also Sri Lanka, how can we be sure that he will act in the best interest of Sri Lanka when he is making decisions on behalf of the country after being elected to parliament?
Ask the people who vote for them.
So we can't be sure?
Ask the people who vote for them.
We can't be sure?
No, because they are sure only they vote for him.
Right. Thank you very much, President's Counsel Razik. We've had quite a great conversation today regarding the 20th Amendment to the Constitution. Some might call it controversial, but it's the substance of the law. And that is really what we aim to discuss here on the role of law. Thank you very much, sir.
We were discussing a bill, remember that?
The bill, yes, exactly.
We are not discussing a law.
Of course, we would love to have you once again on our show, sir, to discuss more issues that crop up here in the legal arena here in Sri Lanka. Thank you very much to all our viewers out there for tuning in as well. Until next time, take care and God bless.
Thank you very much, Shalom.